by simply going into the forum. Now remember what I said, that when we're talking about torts, we're talking about a plaintiff pleading the court to do something. This guy hit me with a car, Your Honor. Please make him fix my car, fix my back, or at least pay to fix my back, and pay me for the lost wages. I couldn't work for 2 months. I need him to pay me to make right these things that just fell upon my life because of his actions, even if they were unintentional actions. Well, the complaint is that first document where you're asking the court to do something. You're asking the court to make right the wrong. Usually before the complaint is sent, there's going to be an investigation. As the paralegal, you may be a part of this investigation, interviewing the client, interviewing witnesses, trying to draw a picture of what happened. Then the attorney is going to send a demand letter, which the paralegal may be the one actually drafting the demand letter. The demand letter is that part that I said is very unlikely to actually get you what you want, but it's a necessary step. Think of it this way, the demand letter. You're demanding that the party that did something wrong against the client make the client whole in some way, pay something. Think of it in a parental sort of way. You have a kid that comes up to you and says, that kid has my toy. The other kid has my toy. Well, you could do one of two things. You can go and tell the other kid to give his toy back to your kid. Or the more likely situation is you'd say, well, did you ask him to give the toy back to you? We kind of expect that someone would take it upon themselves to be responsible enough to ask kindly to get what you want before taking it to the next level. Before going to court, you need to ask the other party to do what, you need to give them the opportunity to do what you want them to do. And that's where the demand letter comes in. You very sternly are demanding from the party that injured the client to pay the medical bills, to do all these things, because it's right to do that. The demand letter may lead to talks and a settlement. So the other party may say, okay, I don't want to be sued. I want to do what's right. I want to make you whole. But I read your demands in the demand letter and they're just outrageous. I did not cause you $1 million worth of injury as you demand in the letter. So let's sit down, figure out how much I need to pay you to make you feel like this never happened. And then we might settle. I might agree to do these things. In return, you agree not to sue me. If that doesn't work, then the complaint is filed in court. You don't want to pay me, so I'm going to sue you. I'm going to force you to pay me. I'm going to ask the court to force you to pay me. So what's the complaint made of, or what sort of items are in a complaint? And for those who were in my civil litigation class last semester, you should know this. But this is an overview. So what you're going to see in the complaint is a statement of jurisdiction. And by that I mean you're telling the court why the court has the authority to do what you're asking them to do. You're telling the court, I'm asking you to to extract this money from this other person. Well, the first question that needs to be answered is, does the court even have the authority to do that? That's where jurisdiction comes in. So the complaint will say, Judge, this is why you have the authority. Pursuant to statute such and such, or constitutional article such and such. You'll have a list of the parties. My name is such and such and I'm suing so and so. Summary of the elements in the case. And I use the term elements here. An element is a building block of a tort. So for instance, I mentioned trespass, for instance. I said a court may say, or the law of the state may say that trespass is just entering onto another person's property, period. Well, the elements to that would be entering upon, second element, another's property. So the actual physically entering upon another's property. There could be more elements. For instance, that secondary, or what I had mentioned, the loser wanted to see the court say, enter upon another's property with the intent to deprive the owner of his use of the property. So then you would have a third element, intent to deprive the owner of the use of his property. So each of those are elements, and if someone is suing for trespass, they're going to have to include each of those elements. They're also going to have to specify generally the facts that support the elements. So, defendant, or the elements for trespass, the defendant must enter upon another's property. The defendant in May entered upon, or entered upon my property, the plaintiff's. So that statement of facts is all that's needed in a complaint, short and sweet, and you're going to have to prove that in trial. Right now you're just kind of telling the judge, here's the lowdown of what's going on. And then of course you need to specify relief. Judge, you have your jurisdiction, you have the authority to hear this case and to get what I want from the defendant. By the way, I'm the plaintiff and he's the defendant. He trespassed on my property. Trespass means X, Y, and Z. And here's the facts that support X, Y, and Z. And then you'll find that all these things are true. So I want him to pay for having to cover up his footprints, or crushing my beautiful flowers that I've planted over the years, etc., etc. So those are the general elements of a complaint. What you'll see in response